Good afternoon. Welcome back to episode 17 of Injustice for All with Judge Joe Brown. And today we're going to be talking about birthright citizenship because on May 15th, SCOTUS heard arguments regarding the 14th Amendment, i.e., birthright citizenship.
Technically, they didn't.
Right. But, well,
that was one of the things that some of the justices were discussing, that all of that was in front of them wouldn't get to the core issue of the 14th Amendment, which they really can't do anything about except interpret. And what they were pointing out was it was procedural. And the real problem is that in recent years, people have been able to go all over the country and get blanket injunctions against the federal government by essentially, they didn't really say it, but forum shopping. In other words, they talked about this went through San Francisco and now it's in Texas, and people basically are just picking where they think they can get the most favorable thing. So one of the issues was who has standing outside of named parties or some class action for a specified class to come up and claim benefits. So that was the main problem that they were dealing with today, is what is the impact of whatever we do? Does it have some far-reaching consequence? Because we don't even have the issue of whether or not the 14th Amendment does apply. We just have the issue of whether or not, and this is important, a district court can enjoin the federal government from doing something until this is resolved. So that's basically what they were talking about. And the disingenuous part of it was the way that the plaintiffs had cast what they were doing. So, well, I say disingenuous because it's still, to me, avoiding the obvious. It's something they established more than a half century ago. It's called Wong's Son, and that is the fruit of the poisonous tree. Wong's Son was a case where the police authorities did something illegal and got evidence. So the Supreme Court held that caused a poisonous tree to sprout, and anything that grew off of or fell off of that tree could not be used. And the poisonous tree doctrine that nobody's talking about, that goes to the 14th Amendment aspect of it in terms of does it apply, is the people that are asserting this would not be in a position to assert it but for the fact that they grew from a poison tree, and the poison tree was their illegal entry. So I have not heard anybody talk about that yet, and I think it's perhaps premature to expect it because the case hasn't gotten that far, or at least the issue hasn't gotten that far. That's the underlying one of what is the real deal with the 14th Amendment. And the press has cast this in the wrong way by saying that's what they're doing. Right now, they're dealing with the procedural aspects of if anything happened, what is the effect of, if anything happens based on what the Supreme Court may rule, what is the impact, who gets affected by it, and who can claim protection under whatever we do. So
they did say at the end, because this was only like 2.5 hours, close to 3, but at the end they said, okay, we will pick up arguments on again on April 22nd. And so is that the part where they may go further into the 14th Amendment?
It's nobody's briefed the 14th Amendment. They're just talking about the procedural aspects. In other words, can this district court enjoin the whole country, where anybody that is maybe in this situation can claim protection, or are they just dealing with named plaintiffs in this case? So there are a lot of procedural and administrative aspects of this thing that are kind of up in the air because the situation is new.
It says here at Advisory Opinions was live for a breakdown of this morning's argument. The justices heard oral arguments in Trump versus CASA, the emergency docket dispute over orders blocking President Donald Trump's effort to end birthright citizenship. Earlier today, the court issued its opinion in Barnes versus Felix.
Well, see, that's not even a correct statement of the case. There is nothing in front of anybody to end birthright citizenship as a thing or a concept. It's just, who does it apply to? That's what the question goes. And see, the government's position is no how, no way did anybody intend to have birthright citizenship, which was set up to counter Dred Scott as it impacted, that's a case heard before the U.S. Civil War that impacted Negroes, colored, black folk, former slaves after the Civil War. So the 14th Amendment had that proviso in there that's been called birthright citizenship to deal with saying, I don't care what Dred Scott said, now anybody who is a former slave born here will be considered a citizen of the country. Also that applied, and they didn't talk about it, to American Indians, Native Americans, Amerins, depending upon how you want to say it. Now, that is what we are talking about.
Can I play a clip from?
Go ahead.
Okay.
Putting the merits aside, what do you think is the origin of, or at least the pedigree of universal injunctions, particularly the Bill of Peace, if you would discuss that?
Absolutely, Your Honor. So there's two categories of these broad injunctions. So first, although we use the term nationwide injunction, if the nationwide injunction is actually about meeting our harm and the alternatives are not legally or practically workable, then it isn't even a universal injunction, as I know this court's separate writings has used the term, because it's about meeting our own Article 3 injury, which is our basic submission about this case. But we do agree that there's some space for universal relief. We trace it back through the history from the Bill of Peace, through Equity Rule 48, which specifically clarified that in the American equitable tradition, it was not always the case that universal relief would bind the non-parties, even as it might benefit the non-parties, continuing on to the tax collection injunctions in the 19th century, and then continuing on as recently as this court's order in AARP. So I do think they've always been in narrow circumstances. They've never been the reflexive or norm of how relief should be granted in this country, but they have been available. I don't think I need that for my case, but I do think they're available in narrow circumstances.
You say they should be available only in narrow circumstances. Why is that?
Yeah, so I could offer the three that I think make the most sense, but we're mindful of some of the concerns that the United States raises. We are states who've benefited from federal policies. We are states who have our own statutes and policies. So sometimes we are on the other side of the V in cases involving universal relief. So we are sympathetic to some of the concerns the United States has about percolation, about running the table in particular cases. We just don't think that that supports a bright line rule that says they're never available. And we've identified, I think, at least three circumstances where they would make sense to be available. The first would be in cases where the alternative ways of remedying the harm for the parties are not practically or legally workable. That's this case, and I'll return to that in a second. The second would be congressional authorization. So I took my friend on the other side to try to set aside vacatur, but I do think their Article 3 objections would raise serious questions for remedies like vacatur, for remedies like the Hobbs Act, even the Hobbs Act, which could set a nationwide PI after a multi-circuit lottery, might ultimately have problems under their view of Article 3. And then the third thing I would say is there may be cases in which the alternative forms of getting non-party relief are not legally or practically available. So that might be a case like AARP, or even a case like this one, where district courts could consider the availability of the class action device, but if it couldn't move fast enough, because Rule 23 doesn't include TROs and PIs, if it couldn't move fast enough in those contexts, courts might need to step in anyway. But I think we fit in the first bucket in this particular case, because the alternative ways of remedying our particular significant pocketbook harms to the tunes of millions of dollars can't be remedied, as the district court found below, without granting us this kind of relief.
And also they talked about whether or not the government could show any particular harm. The government could show is the number of people who might get murdered, raped, robbed, whatever, as a result of the illegals who would be able to remain or anchored in the country.
Well, that clip was Justice Thomas Press's attorney in Birthright Citizenship case. What is the origin of universal injunction?
Well, see, that's technicality. In other words, let's say that I bring a case in Memphis, Tennessee, and we're talking about something here, and I get an injunction against the city administration in Memphis, Tennessee, because that's who's harming me, the way I look at it. Would that injunction against Memphis stand universally against the entire state of Tennessee and against the United States of America if the rest of the people in the country or another area or district are not named? You see what I'm talking about there? In other words, you've got a body of plaintiffs who sue in one district court, say San Francisco, or somewhere Dallas or Houston down in Texas, or somewhere in New Jersey, and they're talking about a group of people that live there. Does an injunction relative to that small group of people apply to the whole United States of America? You see, that's the question. And it's coming up these days where people are trying to use procedural methodology to impact the policy of the United States as a whole. So you can't get a legislative resolution of it. And you go in and say, I'll pick and choose whatever forum I get, where, okay, most of the people on there were appointed by either Clinton, Obama, or Biden, so let's go pick them, versus somewhere where you've got Bush 1 and you've got Trump, or maybe somebody in the Reagan administration appointed the person that's sitting on the bench.
Well, I have another clip of your friend, Justice Ketanji Jackson.
Head scratch.
Yeah, head scratch.
Wig weave.
Ooh, imitate her again. Imitate her again.
I can't do that.
Do the head scratch.
It has to be spontaneous. You need something to go up under the wig. So, you know.
All right. So this is about.
I thought the wig was going to fall off. I was going to be horribly embarrassed for her. I mean, all of this, see, none of this actually deals with what the 14th Amendment says or it's about. The thing is, will there be a universal injunction applying to the entirety of the United States of America across the whole United States of America while we are trying to figure out what the 14th Amendment means when it comes to bestowing this birthright citizenship upon the progeny of those who are illegally here?
Right. And I'm just playing the clips because.
In other words, see, there's an underlying principle, which is for English and American law, the idea is repugnant that somebody is to get an advantage by breaking the law. That just is not done in common law, nor hopefully with statutory law, unless some idiots decided to try and be tough on crime and come up with that by accident. In other words, what the position of the plaintiffs is, well, nominal plaintiffs, the ones that are trying to get a stay on Trump's order, is right. Prosperous under American law. In other words, these people broke the law, so because they temporarily got away with breaking the law, they should be able to get an advantage.
Yeah, and so the only reason why I'm playing these clips because a lot of people were listening, but you know,
they didn't get it. It's real.
Right, so me playing the clip, you're able to let me summarize and break it down for you to make it plain to the audience. You know, people like myself. So this is Ketanji Brown Jackson grills a Trump lawyer about universal injunctions in birthright citizenship case.
In the case,
injunctions in birthright citizenship.
Yeah, we aren't dealing with birthright citizenship. We're talking about the injunctions. And
What
the
does that mean,
Supreme
injunctions?
Court, can you enjoin the whole U.S. government based on what happens with a limited class of parties and interest? They aren't getting to the primary thing because that's to be resolved either through amended proceedings or upon invitation by the Supreme Court at a later time. All they're dealing with is, can you stop the U.S. government and enjoin them from carrying out what they attempt to do right now? And then one of the other pragmatic things is, what if they don't? Who has standing to try and bring somebody in for contempt, and who would you bring in for contempt if you tried?
Well, let me know when you want me to stop, okay?
Okay, go ahead.
So as far as I can tell, your bottom line seems to be that what you call universal injunctions give relief to non-parties without going through the necessary steps, which you identify in Rule 23. Do I have that right? I mean, is that sort of like boiled to bare essence what you're saying?
I would say there's a lot more to it, but
Yeah.
that's one very important point.
That's a key point that I want to focus in on for a moment. I guess I don't understand why you are saying that these kinds of injunctions are giving relief to non-parties. First of all, I think they can be also easily characterized as focusing only on the defendant pursuant to the court's jurisdiction, personal jurisdiction over this person relative to the subject matter jurisdiction that the court has, and the relief is telling the defendant, stop doing this thing that the court has found to be unlawful. So rather than characterizing it as a quote-unquote universal injunction, I think one could easily see that this is just about the extent to which the court can constrain a defendant over whom it has personal jurisdiction. Can it do so completely or just partially with respect to, just say stop with respect to this plaintiff? Am I I don't understand where this idea of universal injunctions comes from in this context.
I think the relevant distinction is an order that orders, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This thing, this executive order, I mean, we do this in the APA context all the time, right? The statute says you hold that you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant from doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to...
Stop this before it gets more confusing. See, in other words, the particular impact of Trump's executive order may have a peculiar negative effect upon a specific category of persons, all right? Now, whether or not ending birthright citizenship to the progeny of illegal immigrants where they should not have been here to avail themselves of this claim as a general category is different from saying these people here have been here a long time, and because of some other things, we wind up saying, hey, we might put in ancient doctrine or ancient practice. They've been here 20 years or 18 or 19 years or 16 years versus what do we do with somebody that just snuck across the border last year while 6, 7, 8 months pregnant and delivered here? What do we do with that one? See, it may depend upon the circumstances, and we still have not resolved this issue anywhere in there as to whether what Trump did is per se illegal in terms of the interpretation of the 14th Amendment. Now, they're talking about precedent, but then again, remember when you had Brown v. Board of Education in 1954, where the Earl Warren court, Earl Warren had been the Republican governor of California prior to being disappointed through Eisenhower. What the decision was based on Dred Scott, which is what the 14th Amendment was trying to overdo. It was dealing with Plessy versus Ferguson, which allowed separate but equal. And what happened in 1954, the Supreme Court reversed its trend and said, oh, we were way wrong. There's no way separate but equal can be equal because. So we may have an interpretation that the parties representing the illegals are contending is we've done this in the past, but just like the U.S. Supreme Court in 1954 said, we've been doing this for the longest time, but it's way wrong. We can't. That's what the Trump administration is saying, because it would establish this counter principle of if you violate the law, then you can profit by it. And see, no way, no how do you want to embrace with your system the principle that if you violate the law, you can prosper by it under the highest court's rulings. Because, see, if you put that in there as to crashing the border and getting benefit for your progeny, then you can expand that to other things by saying, okay, this is the principle they set forth. This is the holding relative to you can prosper through your illegal activities. And it's okay, and you will be protected. Now, if they put that in, I can think of a whole lot of other things that will have some very nasty consequences and fallout. And I think this pattern of those who want to disregard American law and the status of our borders supposedly being sacrosanct, they just don't want to deal with those consequences, and they want to carve out exceptions. One of which I have a particular problem with, which is statute of limitations. Just to give an illustration, right now, because it's politically correct to protect women, you want to give somebody who has been sexually battered, insulted, behind squeezed, or somebody groped, you want to give them a statute of limitations that's 10, 15, 25, 50 years, temporarily no limit at all. But if somebody is killed and the relatives want to bring a wrongful death action, they only have 1 year or 2 years to do it, depending upon the state. When does a butt pinch get to be more grave than somebody getting murdered? You see, these are the kinds of things that come up as perhaps unintended consequences when somebody decides that they're going to zealously go out and say, we need to put these protections in place where we have an affirmative action when it comes to remedies, which don't exist for everybody. See, that brings into play a number of things that I can see will wreck the law.
Justice Kagan?
So, General, on this question of expedition, I mean, it sort of depends on the government's own actions in a case like this one, where one can expect that there is not going to be a great deal of disagreement among the lower courts. I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue, and that you never take this question to us. I mean, I noticed...
Stop a second. I've heard this, so I know what's going to happen, but I'll make this comment. Yes, it's a losing issue in most of the courts, but the issue that the conservative majority on the court keeps bringing up is which courts got picked so that could be achieved, and does that in fact represent the interest of or the holdings that would be held all across the country where this to come up. So, in other words, Sotomayor or Kagan here is asking a question that some of the rest of them hold to be specious. But anyway, keep going so the people can hear.
That you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, and what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is, we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, after we've said that this all has to be done one by one, then we're going to take a case from somebody who objects to proceeding one by one?
I'm not sure I understand the question. I understood the hypothetical.
If you win this challenge and say there is no nationwide injunction and it all has to be through individual cases, then I can't see how an individual who is not, being treated equivalently to the individual who brought the case would have any ability to bring the substantive question to us.
They would bring a lawsuit in the federal district courts against the government for an injunction protecting them. And if the government wasn't respecting, on the hypothetical circuit precedent.
Then they win. And again, you need somebody to lose. But nobody's going to lose in this case. It's just you're going to have, individual by individual by individual, and all of those individuals are going to win. And the ones who can't afford to go to court, they're the ones who are going to lose.
The tools that are provided to address hypotheticals like this, again,
This is not a hypothetical. This is happening out there, right? Every court has ruled against you.
We've only had snap judgments on the merits. Obviously, we're fully briefing the merits in the courts of appeals, and our arguments are compelling. More fundamentally, in response to the question.
I'm suggesting to you, the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything. It's losing a lot of individual cases which still allow it to enforce its EO against the vast majority of people to whom it applies.
And again, Rule 23 provides an avenue to address those very concerns.
Thank you.
Justice Gorsuch?
Well, Justice Kagan asked my questions better than I could have.
Yeah, that's just what we were talking about are you really getting to the issues or what? And she's saying, you're losing in all of the case. Yeah, but, you have 10 districts, you have 10 circuits in the federal system. And all of the courts are not concentrated in not concentrated, but not evenly strewn across all of these various circuits. They're just in 3 or 4 of them. And the parties to this, both the government and the people that are interested in protecting the illegals, they are obfuscating. They're trying to use the procedural aspects to get what they want. And perhaps what one side is doing is saying, we want this stopped until maybe we can alter the politics in Congress, or maybe we can stall into the next election cycle and do better if the Democratic Party can come up with something that appeals to the American public instead of boys and girls' bathrooms. And the Republicans are saying, hey, we need to deal with the procedural aspects. I mean, they haven't shown cause why we should grant these injunctions right now. Because how can you say they will be irreparably harmed if what happens to them was what's supposed to have happened to them in the first place? You know, that's like, hey, we got to enjoin them from doing this because these guys should have been in the penitentiary because they committed all these armed robberies. So let's put a stop on locking folk up for armed robbery while we, you know, have an armed robbery case. We haven't heard where the underlying definition of armed robbery has not been developed. You know, so that's the kind of thing that is of consideration here. But it is what it is. Now,
so I want to share this. This is Justice Sotomayor's speech to the lawyers today. This is just a quote. She says, "If you're not used to fighting and losing battles, then don't become a lawyer. Our job is to stand up for people who can't do it themselves. Right now, we can't lose the battles we are facing." Well, she said it's to a speech to lawyers. So this wasn't today. This wasn't at the hearing today, but this is her being quoted to a group of lawyers.
Yeah, it shows where she's coming from.
Well, she's also fighting for the illegal migrants.
Yes. See, we have partisanship on the Supreme Court, and that's why it's important to determine who's in the White House, who gets to make these appointments, and who's in the Senate, who deals with confirmation or rejection.
Now, during her arguments today, Thursday, May 15th, for the Birthright Citizenship, I've heard her say that there were 3 other rulings made by the Supreme Court regarding citizenship or birthright citizenship in the past.
But they didn't apply to these kind of situations.
Okay, so you heard her say that today.
You sent me that, and I checked in. In fact, you knocked me off once.
Right,
you called me.
And I was trying to look up those cases. She didn't name those specific laws that was ruled on regarding birthright citizenship in the past, but to your point, like you just said, it did not apply to the situation that we're in now. So what makes this situation that we're in now, that this administration and Trump administration is trying to correct or push back, you know, or just change?
For a number of reasons. Nobody has raised the issue before of, hey, are you going to let people profit from breaking the law? And see.
And how are they profiting?
In other words, if you hadn't broken the law, you wouldn't be in the first damn place to have a child become a citizen through so-called birthright and anchor you.
Okay, yeah. So the profit is the privilege of your child being a citizen and you being
if you had broken the law, your child wouldn't be here. So it's just like, hey, are you going to say that somebody is getting chased down by ICE who is running across the border and gets tackled 100 yards inside the border, and all of a sudden, oh, I'm giving birth, and they pop something out that becomes a citizen right there when there's a hot pursuit situation?
Yeah.
You know?
Well, the Supreme Court is expected to hear arguments regarding birthright citizenship on May 22nd, 2025. The justices will be considering a case that challenges the constitutionality of the Trump administration order that restricts birthright citizenship, particularly concerning automatic citizenship for babies born in the United States. The case also raises questions about the authority of federal district court judges to issue nationwide injunctions to block such orders.
Okay, let's, to make an extreme example, let's suppose there are some coyotes, that's what they call the people that help those sneak across the border, who've got a business going. If you are 8-9 months pregnant and you are supposed to deliver imminently, please contact us. We will smuggle you across the border so you can have your child in the U.S. Your child will be an American citizen and you will be anchored and they can't touch you. Now, how does that sound?
Yeah.
Yeah, see, if they go for the position of those supporting the illegals, that's exactly what you're putting in place. That doesn't sound too good, does it?
No, it doesn't. Now, here is Trump on Truth Social. He posted this on Truth Social. I'm trying to give me a second. 1 second. Let me just go to Truth Social.
And see, there's another thing too. Well, Your Honor, the defendant is pregnant or the defendant just delivered a child. We can't lock her up. Why not? You can bring in Department of Human Services who can put the child in a foster situation. She was in an armed robbery and 3 people got shot. 1 person died and another one's paralyzed. So because she happened to, in the interim, be pregnant and deliver a child, she gets out of penitentiary time? No. You can put the child in a foster situation. See, by extrapolation, what they're doing is demanding that the United States behave in what somebody says is a humanitarian fashion. It's the same kind of thing that says we can't have a death penalty because death penalty is wrong, but somebody else says, oh, well, yeah, but we in this state want the death penalty. Over there, they don't. So it's kind of that situation. Some people are saying for humanitarian purposes, we have to keep the families together, when other people might say it's just like when one of the family members is a parent who gets locked up for a serious felony. You don't say, no, you don't have to go to jail because you have children. You put the children in a foster care situation. So we could technically foster these children and wind up raising them as U.S. citizens. And if we had a war in 16, 17 years and reinstated the draft, they could be prioritized to be going in and being cannon fodder,
So,
hypothetically.
yeah, Trump, he posted this on Truth Social today. He said, big case today in the United States Supreme Court. Birthright citizenship was not meant for people taking vacations to become permanent citizens of the United States of America and bringing their families with them, all the time laughing at the suckers that we are. The United States of America is the only country in the world that does this. For what?
Yeah, it is just about, really.
For what reason? Nobody knows, but the drug cartels love it. We are, for the sake of being politically correct, a stupid country. But in actuality, this is the exact opposite of being politically correct. And it is yet another point that leads to the dysfunction of America. Birthright citizenship is about the babies of slaves. As conclusive proof, the Civil War ended in 1865. The bill went to Congress less than a year later in 1866 and was passed shortly after that. It had nothing to do with illegal immigrations for people who wanted to scam our country from our parts of the world, which they have done for many years. It had to do with the Civil War results and babies of slaves who our politicians felt correctly needed protection. Please explain this to the Supreme Court of the United States. Again, remember, the Civil War ended in 1865 and the bill goes to Congress in 1866. We didn't have people pouring into our country from all over South America and the rest of the world. It wasn't even a subject. What we had were the babies of slaves. Thank you for your attention to this matter. Good luck with this very important case. God bless the United States of America.
That's the reality of it.
Yeah.
I mean, nobody anticipated in the 1860s that 160 some years later, we would have this issue where there is a mass influx of basically the entire population of the United States of America during the Civil War has crashed the southern borders in the last several decades. the number of people that have crashed that border are larger than some of the world's nations. So nobody anticipates that kind of situation. Never heard of it, never anticipated it, which is why the law grows. It evolves with society. It has to, because there are things that come up. Like, for example, piracy, thanks to a number of treaties, includes hijacking airplanes. When they wrote the Constitution, nobody had ever heard of an airplane. I mean, that was a couple of 100 years in the future. So, well, 150 years in the future, 130, when the Wright brothers got into the air in 1906 or 1903. So what the devil is going on here? We have to deal with the realities. Nobody thought about this. So you want to say, oh, this thing that came up way back when, after the Civil War, where trains were going 65 miles an hour and doctors were arguing that a human's heart would stop if they were on board a train going 65 miles an hour. Hey, times change.
All right, perfect way to end. And thank you guys for tuning in to another episode of Injustice for All.
Wow, we whoopee.